and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialist. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. How are you? It's cold here.
I'm very well. Yes, you're fortunate to have some snow at least, but no such thing down in the south.
Oh, never get snow in the south.
So we're going to be talking today about the proposed reform to the Landlord and Tenant Act 1954. It's an act we talk about quite a lot on the podcasts and in the webinars. But do you want to start by giving us a brief history of the act and setting the scene a bit?
Yeah, it actually goes back to 1951. People don't realise there was a Leasehold Property Temporary Provisions Act of 1951. Amongst other things, it was dealing with the aftermath of the Second World War, you've probably heard of, Lizzie. And she says yes. They sort of bombed out cities and towns up and down the country and trying to attract leaseholders by giving them a degree of security to start running their business again. That was the background to it. And it was, gives the lie to it. It was called the Temporary Provisions Act back in 1951. It was reinstated in the 54 Landlord and Tenant Act. And part two is one of the fundamental provisions in the world of leaseholds. And things have changed a huge amount. I mean, currently, there's almost, the estimate is that commercial properties in this country to be valued altogether to just under £900 billion. It's a major part of the economy and the likes. It's changed since its inception, the 54 Act. It changed the 1969 Law of Property Act, which introduced contracting out, the warning, not warning notices originally, but contracting out through court order, which wasn't in the original act, and obviously huge numbers of landlords and tenants just, will contract out of the act, which to some extent gives the lie to it. And then it changed again over 20 years ago when I was just a young lecturer with dark hair. It changed when the Regulatory Reform Business Tenancies England and Wales order came into force. It's 2003 order. It was delayed in its implementation, I remember, and came in June the 1st, 2004. And that changed the process of contracting out from. And again, people won't remember the days when you had to troop off to court and spend £130 to get a court order to contract out. It introduced the warning notices, at least 14 days running period, a simple declaration, otherwise a stat dec, and also speeded up the ability to go to court. In the past, it was only landlords who could apply to courts. Now it's landlords and tenants. And also in the past, only landlords could apply for an interim rent as a way of increasing the rent before the end of the existing lease or the beginning of the new lease. Now it's either party. But that's over 20 years ago now. What then happened is, it's been talked about for some time, quite honestly. I wouldn't hold your breath. But in December of 2020, the government of the day, the Department of Levelling Up, and Michael Gove, if you remember him, whatever happened to him? He's the editor of The Spectator and he's got his own radio show. But they sort of suggested that the Law Commission should look at reforms, but nothing happened. Then in March the 28th last year, 2023, the Law Commission started looking into reforming the Act. It's moved on a huge amount. It moved on a huge amounts with things like the financial crisis of 2008, and it moved on with sort of online shopping and the needs of the high street, not what they were, and also with the real spur, I suppose, was the lockdowns and COVID. So they'd look at this, and they were going to produce the consultation in December of last year. Then it was going to be produced. It wasn't produced in December. It was going to be the spring of this year. It was finally published, the first consultation paper, 118 pages, which we're now going to go through systematically. But no, we're not. But it was produced on November the 19th, a few days ago. But it's only a consultation paper. It ends 3 months on from that the consultation, the first consultation, on February the 19th, 2025. Do you know why that's an important day, Lizzie?
No.
It's my birthday.
Oh, I
Um,
should have known that. Sorry.
Yep, I'll be 39. Uh,
Again.
no, 39. I was 38 last, as you know. But anyway, so that's the importance. That's why they chose that day. But it's only then going to give rise to a second consultation. We don't know when. They'll decide how many responses they have to the first consultation. So unfortunately, it's a long way away. But it has been talked about for many years.
So why should there be further changes to this in the future, do you think?
Well, it is massively out of date. I can understand that. I mean, sometimes, it's like the world of residential. Successive governments seem to think all landlords are nasty and all tenants are nice, humble creatures who need our help. You know, commercial tenants who are amongst the biggest profit-making organizations in the world. And, the high street might need the help, and I'm not sure everybody does. And contracting out is so commonplace that it gives the lie, to a lot of the legislation. And also, the market has changed since the original 1951 provisions, not least of which with online shopping and the post-COVID world and the likes. And so I think it does need changing.
So what are the Law Commission's suggestions?
Well, I won't go through, as I said earlier, the whole 118 pages, but they've suggested several alternatives, 4 alternatives to be precise. Firstly, that there'll be no security of tenure. The 54 Landlord and Tenant Act will go. That'll put me out of a large part of my work, Lizzie, if that happens. It's very difficult to do a course on it, but you'll be glad. They don't have it in Scotland. It's only England and Wales that the 54 Act applies, and they seem to get on okay in Scotland. And it'll all be down to contracts and market forces. And if you want a degree of security, what you'll do is basically have an option, a contractual option. Instead of having a 5-year 54 Act protected lease, you just have an option to renew for a further 5 years. And that's one possibility. It will, I suppose, give rise to, say, market forces will dictate these things, and you'll have to negotiate those kind of things. I don't think that's necessarily a bad idea. It'll be a sort of complete wrench away from what we're used to, but that was the first possibility. The second was to reverse the burden. Nowadays, you have to serve the warning notices before the tenant commits themselves for the tenant to contract out of their rights. The suggestion is in the future, it'll be the other way around. You'll contract in to your rights, which again, actually makes some sort of sense. A lot of people don't contract out because in the high street, they've never heard of contracting out, or they serve the notices incorrectly, or the 54 Act excluded lease comes to an end and there's no negotiations for a new lease and the tenant just stays put, paying the rental and so on, and they will have 54 Act protection. So that's the next possibility. The third possibility is contracting out of the Act, which is basically we've got at the moment. I suspect that's what's going to happen. But I think it needs quite a few changes, even then, not least of which at the moment, disputes are settled by the courts. And it would make a lot of sense for disputes to be settled by arbitration and the likes, not unlike they had with the Commercial Rent Coronavirus Act. If you remember, we did seemed a long time ago, we did a podcast on that in the past. And so it'll be determined more rapidly and cheaply by arbitration. And also talking about things like compensation for disturbance having to change because it's based on rateable value, which is a bit out of date. And the fourth possibility was full security, no ability to contract in or out. And I think that's probably the least likely. I think that's definitely the least likely. So we've got to wait to see what the future holds. I mean, I have seen other people suggesting things like one of the problems at the moment is landlords inadvertently just allowing tenants in at the beginning of the lease, no written agreements. That's what happens in a lot of the high street. And suddenly they got 54 leases. And so the possibility is like, the lease must be a written agreement, something like that. Or a protocol to decide, experts can determine disputes and what the new term should be. So we'll have to see. We'll have to see what the results of the first consultation are, but that won't be until well into next year. And we'll have to see for the future. It's taking a long, long time. And we'll keep you posted.
We will indeed. Thank you very much, Richard.
My pleasure as always, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.